This is Duke University.
So let's see. We're gonna start. Welcome. I'm Noah Pickus. I direct the Kenan Institute for Ethics here at Duke, and this is a joint production of the Kenan Institute and Duke Law School and the Program in Public Law and the American Constitution Society. And it's also one of a series of events. The next one I want to call your attention to is also here at the law school on April 4th, and it's Who Makes Your iPhone? Chinese Migration, Labor, and Human Rights. You'll see these posters, and feature several faculty from here and from George Washington talking about issues of Chinese migration, labor, and human rights. So that's on April 4th. Our topic today, of course, is the constitutionality of SB 1070, and to the degree relevant, it's House Bill HB 2162, in terms of this focus on new state law requirements for the enforcement of immigration law. Let me sketch out briefly what we're going to do here. We've talked about, amongst ourselves, about two broad areas to focus on today. The first is thinking about the constitutional dimension of the issues raised by SB 1070, both in terms of some of the conversation more broadly about due process and equal protection and 14th Amendment and so forth, but also and especially the focus on the structural aspects and the questions of federalism and plenary power and the Supremacy Clause, and a series of issues that raise both core constitutional questions and even broader issues about citizenship and about the shape of our politics. And we're going to focus primarily on those substantive and structural constitutional issues in the first round of conversation, which I'll lay out in a moment. And then after that, I'll just ask the panelists to comment more broadly on some of the political implications and dimensions and strategies at work here dealing with SB 1070. So that's the larger frame and structure for how we'll go about today, a set of initial formal comments followed by at least one big picture follow-up question. We have an all-star panel here today, which it's been an absolute pleasure working with Margaret who has put all this together. We have Lucas Guttentag, who is a senior research fellow and lecturer in law at Yale, and the founding director of the Immigrants Rights Project at the ACLU. We've been pleased to have Lucas here at least once before, if not many more times. So, so that's great to have that pipeline that Margaret has established. And Jack Chin from the UC Davis School of Law, who writes about constitutional law, about immigration law, and about race in the law. And then we have two in the lineup from Duke. We have Ernie Young, who writes about federalism and constitutional interpretation and the relationship between international and domestic law, and Margaret herself, who is a senior lecturing fellow here in the Program in Public Law, and as many of you may already know, has been a senior policy advisor in the White House and the Department of Justice. So we have a superb lineup here, and the way we're going to structure it is I'll ask Jack will bookend the initial comments. First, I'll ask him to briefly sketch what is the law that we're actually talking about. What are the particulars? So we're all working, if not singing from the same hymnal, we're all, I guess, reading from the same playbook or some kind of metaphor like that. And then we'll have Lucas and Ernie and Margaret, and then followed by Jack, provide their substantive comments on those issues that I raised at the beginning, and then we'll move on from there to open conversation and questions and answers. So with that, let's get started. Jack, the floor is yours.
Thank you. Can everybody hear me? It's a pleasure to be here. I am currently at the University of California, Davis, but I taught at the University of Arizona for 8 years up until July. I say I was deported from Arizona, and there's actually some truth to that. I want to give some of the background of where, very briefly, where SB 1070 came from. So Arizona has always had a sort of contentious relationship with race questions. Arizona voted in 1862 to join the Confederacy, and it was a slave state, part of the Confederacy. It became a state in 1912, and it's fair to characterize it as a traditional Jim Crow state. At that time, it prohibited Indians from voting. It prohibited interracial marriage. It prohibited Asians from owning land in the state. And those things continued well into the middle of the 20th century. It also had a number of restrictions from the very earliest days on the status of aliens. And you can see this in a progression of cases in the U.S. Supreme Court. Truax versus Raich in 1915 dealt with the constitutionality of a voter-passed initiative that prohibited the employment of aliens by corporations and private parties. And the Supreme Court said that that was unconstitutional. You couldn't prohibit the employment of aliens because if you prohibit their employment for practical purposes, you drive them out of the state. In 1971, the Supreme Court invalidated Arizona's prohibition on lawful permanent resident aliens receiving public benefits. So this is some high points of the prehistory of the modern set of issues that Arizona has raised with SB 1070. The modern period begins in the early 2000s when a person named Russell Pierce, who had a very successful career in the Maricopa County Sheriff's Office, retiring as undersheriff to Joe Arpaio. Maricopa County covers Phoenix, ran for and won a legislative office. And Senator Russell Pierce, who ultimately became president of the Arizona Senate, his signature initiative was controlling the illegal alien problem. And so he passed laws to deny public benefits, like in-state tuition, to people who couldn't prove they were U.S. citizens. He proposed and had laws passed that provided that any person who was arrested would be held without bail, regardless, even if they were otherwise not a flight risk, if they were undocumented. And in coming up with this idea, with these legislative proposals, he was aided by a lawyer who was then a professor at the University of Missouri, Kansas City, Chris Kobach, who recently was elected Secretary of State of Kansas. And Professor Kobach's primary work as a legal scholar was writing articles. You know, anybody who says that law professors don't have any influence on the real world, you know, you got to take a look at Chris Kobach, because he wrote these articles that said, here's how you, in your state, can pass laws to drive out illegal aliens. And one of the things that they came up with and put into law was the Legal Arizona Workers Act. It was recently upheld 5-4 by the U.S. Supreme Court that required private employers to go beyond federal guidelines in making sure that they didn't hire undocumented people on pain of losing their business license. That is, business death penalty. You lose your ability to do business if you at least intentionally hire an undocumented worker. That was Russell Pierce, Chris Kobach. They got it through. It survived in the U.S. Supreme Court. And all of that is before SB 1070. Then comes SB 1070. SB 1070 is a long and complicated statute that does a large number of things. It amended existing law in a variety of ways and added new laws. But basically, what it did is that the two kinds of things that it did are that it imposed new duties on the police, state and local police in Arizona, to help aid federal enforcement of immigration. And it created a series of new crimes that basically everyone in Arizona who was not documented under federal law would be guilty of violating. That is to say, if you're undocumented, your choices are to be guilty of an Arizona crime or to leave the state. Those are the only choices. Section 1 of SB 1070 says what the purpose is. The legislature declares that the intent of this act is to make attrition through enforcement the public policy of all state and local government agencies in Arizona. The provisions of this act are intended to work together to discourage and deter the unlawful entry and presence of aliens and economic activity by persons unlawfully present in the United States. So the goal is, as Chris Kobach said, it's true we can't deport every one of these 11 or 12 million undocumented people in the United States. That's impossible. And it would be wrong to legalize them. So, but it's not the case that just because the policy options at either end are off the table, that there's no other option. There's a middle option, and the middle option is to make life in Arizona and in the United States so difficult that people will self-deport. They will choose to leave the state rather than live with the unpleasantness. So what does it do? How does it do this? First, I'll talk about the 4 provisions that are in the U.S. Supreme Court right now on review of their constitutionality. There's a provision that says when a state or local officer in Arizona stops, detains, or arrests a person, and there's reasonable suspicion that they're undocumented, then they must, if practicable, identify their citizenship before letting them go. And the United States Code has a provision that says that any state or local law enforcement officer can call a certain federal agency and find out if any person is identified as an illegal alien. The second thing is that it says that state and local officers can arrest an undocumented person based on probable cause that they've committed an offense that makes them civilly deportable. Crime in the past, crime that they've been convicted of, crime in another state, doesn't matter. If they have the status of being civilly deportable, they can be arrested by state and local police in Arizona. It makes the third thing that's in the Supreme Court is a provision that makes it a crime to work in the state of Arizona for money if you're not authorized by federal law to work. Now, there's no federal crime of working without authorization. It's not a criminal offense. You might be removable, deportable, you might not, but it's not a federal crime. It's an Arizona crime. And it is, the fourth thing is that Arizona makes it a crime to be in the state of Arizona without having registered under federal law. And it is a federal crime to enter without having registered. But it's now, because of SB 1070, also a state crime. So that's what's in the Supreme Court. A few other things that SB 1070 does. One important thing is to turn up the heat on state and local police. If they fail to enforce immigration law, if they fail to enforce the requirements of SB 1070, they can be sued by any lawful resident of the state and pay damages, have to pay damages. Now, if they fail to enforce rape, robbery, and murder laws, they're immune under general principles of governmental immunity. Police don't have to answer when you call 911. But if you call 911 because there's an undocumented person, then you can sue them. Another thing is that states and localities cannot limit their employees' ability to enforce immigration law below the maximum amount permitted by federal law. So whatever assistance federal law permits local agencies to offer, state and local agencies can't reduce what their folks do below that. Another thing that SB 1070 did is that it amended and revised laws that were already on the books in Arizona from the earlier period of Russell Pierce and Chris Kobach's policy development that make it an Arizona crime to transport, conceal, harbor, or shield an undocumented person in the state of Arizona. And so Those are also federal crimes, but they're state crimes as well. So what's new and not new about SB 1070? SB 1070 is not new because it involves state and local officers in cooperative enforcement of federal immigration law. Before SB 1070, state and local officers, when they encountered somebody who appeared to be undocumented in, say, a traffic stop, they would ask them, are you documented or not? And if they said they were undocumented, they would pick up the phone and call Customs and Border Protection or ICE and hold them until the person was picked up. So they did that as a matter of practice, and that's not new. What's really new here is that they have the independent power to prosecute now. It's also not new that they could arrest people for federal immigration crimes. Before SB 1070, under pretty well-established U.S. Supreme Court cases, state and local officers can arrest people for federal crimes of any type, including immigration crimes. But the trick is then they have to turn the person that they've arrested over to the U.S. attorney. And the U.S. attorney makes the decision about whether they want to prosecute or not. And the whole point here is that the U.S. attorney in the District of Arizona spends time prosecuting human smuggling, drugs, guns, money, trafficking, organized crime surrounding the border, but not so much alfalfa pickers and strawberry pickers, which is the target of SB 1070. And so Arizona didn't want to make arrests of people, turn them over to the federal government, and have the federal government not prosecute. And so the real critical innovation of SB 1070 is that if this works, Arizona can prosecute these people under their own authority in their own courts and put them in their own prisons.
Jack, thanks for that, giving us all that primer on the history and the specifics. Lucas, if you could comment briefly on the state of current litigation and then roll into your own remarks, that would be great.
Sure, I'd be happy to, and thank you all very much, and thank you to Margaret especially, and to Noah as well, for inviting me and for organizing this. As Jack just outlined, I mean, the fundamental question here is whether every state can enact, or locality for that matter, every state or locality can enact its own immigration enforcement scheme in the face of federal objection that the state or local law is inconsistent with the federal government's priorities, goals, or the congressional statutes governing immigration law. The Supreme Court will hear that question in the context of these particular elements of the Arizona law on April 25th. The case in the Supreme Court is the United States challenge to the Arizona law. There are parallel civil rights suits against the Arizona law as well that were filed by the ACLU, by the Mexican American Legal Defense Fund, by other civil rights organizations that were actually filed first, but because of the way the case has proceeded and because the district court and then the Ninth Circuit entered injunctions in the lawsuit brought by the United States, that's the case that's being heard in the Supreme Court. The Arizona has filed its brief. The United States just filed its brief in response on Monday. Amicus briefs in support of the Arizona position will be filed next Monday. So for those of you who are interested in reading a slew of legal briefs on this question, they will all be available as of next week. And the case is being heard based from the injunction issued by the Ninth Circuit. So the Ninth Circuit enjoined the Arizona law. The Supreme Court will hear Arizona's challenge to that injunction. Justice Kagan is recused, so only 8 members of the court will be hearing the case. The Arizona law is actually one of a series of state and local laws that you probably all are familiar with. The most famous other law, or notorious I should say maybe, is the Alabama statute, HB 56, that has many of the same elements as the Arizona law, plus additional provisions not presented by the Arizona law that seek to address or regulate undocumented children attending public schools in Arizona through a kind of policing mechanism that asks for parents to verify their immigration status as part of the children's enrollment. The Alabama law also has a provision that prohibits certain kinds of private contracts between undocumented immigrants, undocumented aliens, and any entity in the state of Alabama, and a number of other provisions. The most of the provisions of the Alabama law, other than the law enforcement provision that's similar to the Arizona law, have been enjoined by the 11th Circuit, pending further review and awaiting the decision in Arizona. So there's the Alabama case. Georgia has similar laws. That's been temporarily enjoined by the 11th Circuit. Similarly, Indiana, Utah, South Carolina all have similar laws to Arizona. And then there's an earlier iteration of laws that's worth noting as well from Hazleton, Pennsylvania, and from Farmers Branch, Texas, that had similar provisions to the first round of Arizona litigation, but critically also have a provision that would prohibit any rental of any apartment or house to anyone who can't prove their lawful immigration status. So it seeks to deny housing based on immigration status. And the Fifth Circuit just yesterday enjoined the Farmers Branch housing provision on the ground that that is an impermissible intrusion by a locality into the regulation of immigration, and that it was animated by discriminatory intent, particularly against Latinos. So you see this whole array of laws. Now, the issue in the Supreme Court narrowly is whether or not these various laws are preempted, are inconsistent with federal law. And I think Ernie's going to talk about that a little bit more, and I'm happy to address it as well. But just in terms of kind of framing the larger context, the fundamental concern with regard to these laws is not just that they intrude into the primacy of federal power over immigration, but it's the question of why does the federal government have the principal responsibility here. And that is because, as the Supreme Court has indicated on numerous occasions, that when localities get into the arena of regulating immigration, they often turn to discriminatory laws, the kind of animus that the Fifth Circuit identified, and that with regard to Arizona in particular, for example, the concern is that if every law enforcement officer is required, as Jack laid out a moment ago, is required to determine whether or not there's a reasonable suspicion that someone's undocumented, that will inevitably lead to discrimination and profiling against people based on their appearance, their ethnicity, their accent, and whatever else may inform a police officer to judge whether or not someone is suspected of being undocumented. And in Arizona, of course, this is not a hypothetical issue. This is the state where Sheriff Joe Arpaio has engaged in immigration enforcement and is now under investigation by the Civil Rights Division of the Justice Department for engaging in precisely the kind of discrimination that everyone is concerned will arise and does arise when a local police officer is not only authorized but required under threat of private lawsuit to engage in this kind of maximum enforcement. Now, the preemption doctrine and the preemption principle, as I mentioned a moment ago, is very much concerned about states engaging in discrimination against foreigners or people who appear to be foreign. And that, I think Ernie will talk about, is wrapped up in the question of this is a federal responsibility, and when engaged in by localities, can or will intrude into U.S. foreign relations, our relations with foreign governments, and so on. So how the Supreme Court decides this case will have enormous ramifications for what the role of the states is, and I think that it matters a lot how these different provisions are defended by the state of Arizona, because Arizona has different theories for defending the various provisions of the Arizona law. Some, it argues, are actually authorized by federal statute. Their reading of the federal law allows the states to engage in this kind of enforcement. And others of the provisions, for example, the criminalizing work, not only work by unauthorized immigrant workers, but also solicitation or seeking work is also criminalized. Those are defended by Arizona on the theory that the federal law has not specifically prohibited them. So under that theory, anything that's not specifically prohibited by the states to engage in by federal law would be permitted. That seems to be the broadest and, in my view, the most radical theory proposed by Arizona. But let me wrap up with that so that we can go on to the others. I'm happy to talk about all of these in more detail. Thank you.
Lucas, that's great and gets us right into the larger federalism issues, which are not only about immigration. Ernie?
Okay, well, I too want to thank Noah and especially Margaret for including me on this. I'm not going to say much about the kind of sexier equal protection and due process issues because they're not in the case, right? That's not what is going on in the Supreme Court. And in fact, I want to complain for a second about the title of the program because the racial profiling law kind of assumes an answer to that question. It suggests that if you're for state autonomy over some immigration decisions, you must be for racial profiling. You must be slightly racist at least. And I think there's a problem because I think there's good structural reasons to think that maybe some state autonomy in this area is important. As any of you who've had me in class know, everything at the end of the day comes back to federalism. Let me just explain for those of you who may not understand why they're not in the case. And that is, I think, has to do with kind of the timing of review in large part. There's two real issues that you might talk about on equal protection due process grounds. One is having state enforcement of the provisions of federal law itself an equal protection and due process violation? That would be a very odd position if you're not going to say that the federal law that's being enforced is itself unfairly discriminatory or a violation of due process. So I don't think anybody's going to end up saying that. I think the argument on equal protection and due process will be that the way this gets enforced in the context of an individual stop on the street or something like that does amount to profiling, does amount to unfair treatment of particular individuals. And the thing is, the law has never been enforced, right? It's been enjoined right away. We haven't ever seen it enforced in the concrete context. And we have a distinction in American law between what's called a facial challenge to a law and an as-applied challenge to a law. You challenge a law on its face, you're saying there is no way that this law could ever be enforced in a constitutional way. And that is what you'd have to do at this stage of events, right? Because the thing has never been applied to anyone in particular. I think it's very difficult to say that any possible way that a state official could enforce federal immigration law has got to violate the Equal Protection Clause of the Due Process Clause, no matter how nice about it, no matter how cautious they are about it, no matter how solicitous of people's rights they are. It's got to be unconstitutional. So that's why it's not in the case today. And so if you're looking for the court to make a big statement about racial fairness in this case, you're going to be disappointed, because I think that sort of discussion will come in the context of if this law is ever allowed to go into effect, then individuals will raise as-applied challenges. They'll say, well, the way they enforced it against me violated my due process rights or discriminated against me based on my race. And my view is, some of these people may very well win those cases, right? That sounds like it might be a very decent claim. It's not the claim that we have at this stage. So this is a case about federalism. And I just want to say a couple of things about the federalism issues in the case. The first thing is, there is no such thing as an exclusive area of federal power, period. There's no such thing as exclusive federal power over foreign affairs, and there is no such thing as exclusive federal power over immigration. We used to have a regime called dual federalism, where we divided up the world into state responsibilities and federal responsibilities. And the feds weren't allowed to intrude into the sphere of state responsibilities. They weren't allowed to regulate education or health or intrastate commerce. And the feds weren't, and the states weren't allowed to regulate federal responsibilities like immigration, like foreign policy, things like that. That all came crashing down during the New Deal, when the court made its switch in time in 1937 and said, we're going to allow the federal government to start regulating things like wages and hours and safety and things like that, there were no more exclusive spheres. And they did the same thing in the other direction. They said that there's not really going to be exclusive federal spheres either. And that's why you have cases like the Canis, for example, that don't hold that any state action that touches on immigration is automatically preempted. Right? And I think this is a particularly compelling point in the area of immigration because the idea that federal power is exclusive has a history, and it has a pretty bad history because for a long time the federal power of immigration wasn't grounded in the Constitution at all. It was grounded in the inherent right of the United States as a sovereign power to regulate and control its borders. And the reason why the argument was phrased that way was because the people running federal immigration policy wanted to make it incredibly nasty primarily to Chinese people, and they wanted not to have those people be able to bring constitutional challenges to what they were doing. And so the argument was, well, the federal power to regulate immigration comes from outside the Constitution, and it's not subject to the Constitution, and therefore we can take all your stuff, we can deport you, we don't have to give you any due process. That's the plenary power doctrine. And so it is really strange to hear people invoke the plenary power doctrine and say this is why the federal government has to have the power to exclusively regulate immigration. You know, it's strange to hear that argument from people who care about immigrants because the history of that argument was that it was a way of stripping immigrants not only stripping the states of their authority to intervene in this area, but also stripping immigrants of their constitutional rights. I think it's safe to say that the court is not going to decide this case on plenary power grounds. They're not going to decide it on dual federalism grounds. They're not going to say this is an exclusive area. If you think about it, the states do things that impact immigration all the time. Every time a state decides to have good schools, right, that's going to impact population flows into and out of the states. It makes it an attractive place. Every time the states decide to grant resident tuition to illegal immigrants, which a number of states have. That is an immigration policy that the states have. Every state has trade delegations in other countries. Every state does things that affect our foreign relations. We execute foreign nationals, for instance. So it's simply not the case that there's this exclusive sphere. And I'm not sure we would want there to be in immigration. Not only is the federal record in the Chinese area not particularly good, we also have states that are on the other side of this divide. We have states that want to pursue a more liberal, more welcoming policy than the federal government right now, and the Obama administration is challenging them and saying that that's preempted by federal law as well. So if you're going to preempt states that are more restrictive on immigration, I think you're also going to have to preempt states that are less restrictive. I also think that if we go back to this idea of exclusive federal-state spheres, the idea that the federal government regulates foreign affairs, for instance, and the states regulate, say, I don't know, health policy, then that's going to have implication for other cases that you might have heard of that the court's going to decide this term. The last thing I want to talk about is this idea that it's the enforcement discretion, the enforcement decision of the executive that is actually what's preemptive here. Ordinarily, under the Supremacy Clause, the only thing that preempts state law is laws enacted pursuant to this Constitution, as well as treaties ratified by the Senate, right? Not enforcement decisions by the executive. You have to have a statute, and the ordinary standard in preemption cases is that Congress's intent has to be clear. And so I think that's going to be a very difficult thing to show, because the argument is, except with respect to the soliciting employment provisions of the Arizona law, which I think are in fact going down. The rest of it is just, you're enforcing this more aggressively at the state level than the federal government is willing to enforce it. It's not just that the federal law has preemptive effect, but the executive's decision about how much to enforce the law has preemptive effect, right? That's the core argument here. But that's allowing the executive unilaterally to make decisions that have the preemptive supremacy force of federal law. And I think that's a pretty scary thing to do as a matter of separation of powers. So here's some ways that might impact causes that liberals are more likely to care about. So think about securities fraud. for instance. A lot of states are enforcing the securities law. Elliot Spitzer, for instance, enforcing the securities laws more aggressively than the feds are. Does the fact that the SEC isn't very aggressive in enforcing those laws mean that the states are preempted from going after the companies that have defrauded their citizens? I mean, I hope not, right? Does the fact that the Food and Drug Administration is pretty lax in improving medical devices and drugs on the market mean that the federal executive has made an enforcement decision that preempts actions under state tort law, for instance, to enforce duties of care that go further? I think that would be a problem as well. Does the fact that the federal government decides not to prosecute certain classes of hate crimes mean that states can't prosecute similar behavior under their own hate crimes laws? Right? There's lots of areas of concurrent enforcement discretion at both the state and federal level. I think this is one of those areas, and there are some real advantages to that. It's a check on the authority of the executive at the federal level to decide not to enforce laws that it doesn't like very aggressively. This allows somebody else to come in and pick up the slack. And in some areas we like that, in some areas we may be less comfortable about it, but we need to come to some sort of global principled solution about whether that's okay.
That's great. Thank you, Ernie. And Margaret, just before I turn it to you, am I right, we finish at 1:15?
Right, we do finish at 1:15.
Okay, so we'll have Margaret and Jack with wrap-up comments, and I think or your own comments, and then in the interest of time, we'll just bring folks into the conversation and see where that leads.
Okay, perfect.
So over to you.
Great. So thank you so much, and for everyone to come here today, and this really is a rock star panel, and I feel really humbled to even be sitting at the same table with these giants. But what I wanted to talk about today is something that I call reverse commandeering. And how many of you in first year law, con law, read Prince in New York and learned about the commandeering principles? So hopefully everyone, all hands should be up, otherwise we better fire some of our con law professors around here. So what I'm trying to talk about today is the inverse of commandeering. So applying anti-commandeering principles to what I think is happening right now on the ground with these laws such as SB 1070. So we all know under the Supreme Court's 10th Amendment jurisprudence that the federal government is prohibited from commandeering state officials and state legislatures for their ends. So what about reverse commandeering? What happens when state legislatures try to commandeer the federal government, both the federal agencies and Congress, to their own ends in order to implement their idea of what should be comprehensive immigration reform proposals? So I want to step back a little bit and talk about how did we get where we are, and thank you so much to both Professor Chin and Professor Guttentag, who talked a little bit about the genesis of SB 1070, but let's talk about comprehensive immigration reform and when it failed in 2006, 2007. So what happened after that failure of Congress to enact comprehensive immigration reform? In July 16, 2006, Hazleton, Pennsylvania, enacted a city ordinance called the Illegal Immigrant Relief Act. And who was behind that? That was Chris Kobach, the same author as SB 1070. And then shortly thereafter, it touched off something very virulent, and there were hundreds and then thousands of similar copycat laws across the country where state and local governments said, yeah, why don't we take immigration reform into our own hands, and we can replicate the federal law and the federal immigration scheme. So in July 2nd, 2007, Arizona decided to pass the Legal Arizona Workers Act. It was signed into law, and at the time that it was signed into law, then Governor Janet Napolitano said, quote unquote, it was signed because of our desire to stop illegal immigration, because it is now abundantly clear that Congress finds itself incapable of coping with comprehensive immigration reforms our country needs. And so what this did was it allowed Arizona to basically take over one aspect of comprehensive immigration reform by mandating that every employer in that state to use a database screening program called E-Verify. At the time, E-Verify was considered a voluntary program, but under the LAWA Act, then under Arizona, all employers were required to use this national database screening program. And how this works is an employer then gathers the personally identifiable information of their employees. They run them through an online internet database screening system that runs that information through DHS databases and through Social Security Administration databases. And then purportedly, it's supposed to allow for the employer to verify identity and citizenship status of those employees. Well, this now has led to a situation that is historically unprecedented in our country, where you have delegated immigration screening duties through a database to private third parties. And under in the Chamber of Commerce v. Whiting, you had LAWA upheld. But what also was very interesting about LAWA is the fact that state prosecutors now are able to prosecute for this crime of hiring unauthorized workers if they find at the state court level there was a violation of federal law. And so to contextualize what's happening throughout the United States in a lot of these laws, like SB 1070, like LAWA, like the Hazleton Ordinance, is that since 2006, there have been over 7,000 of these types of laws that are considered at the state and local level. And as of last year, it was estimated that just in 1 year, 1,538 of them were passed in all 50 states. So I'm framing this as basically a hostile takeover of immigration law by the state and federal governments. And let's just take Arizona as a microcosm of this takeover. In addition to LAWA and SB 1070, you have Arizona SB 1611, which is a landlord sanctioning regime. LAWA was an employer sanctioning regime. HB 2008 is a state worker sanctioning regime. SB 1405 is a hospital worker sanctioning regime. SB 1407 is a teacher sanctioning regime, as well as SB 1141. And so a lot of these states and local governments, what they're trying to do is delegate immigration screening to teachers, doctors, landlords, employers, state workers, et cetera, and then sanctioning them to civil penalties and potentially even criminal penalties if they don't screen. And of course, SB 1070 is a police sanctioning regime, trying to punish those police officers if they fail to do immigration screening. And what I'm trying to show in my research is that this has huge cyber surveillance consequences as we move more and more towards this type of database-driven sanctioning regime for immigration reform, and as we devolve it deeper and deeper into the state and local realm. But how did we get here? And I blame largely the federal government for our current situation, because beginning in 1986, with the passage of the Immigration Reform and Control Act, Congress made a conscientious decision that the best way to secure our border is to delegate exactly this type of screening to private third parties. And so for the first time in 1986 under IRCA, Congress said we are going to sanction employers with these federal and state types of penalties if we find that they have knowingly hired undocumented workers. And so now a lot of state and local governments, especially following the lead of Chris Kobach's research and his scholarship, are saying, fine, why don't we just delegate these screening opportunities to all of these other individuals in our communities? And the way that they're trying to get away around the preemption problem is they're saying that basically we are just going to mirror and textually replicate the federal immigration law. So if we speak as one, then there is no preemption problem. And I'm sitting next to basically the person who has written the definitive text on how these states were able to do this. Go to Duke Law Journal, their November 2011 volume. And this article is absolutely brilliant. It's by Professor Chin and also Professor Miller. The Unconstitutionality of State Regulation of Immigration Through Criminal Law. Absolutely brilliant. Where he walks through and explains exactly how mirror image theory works. And then, lo and behold, in the Chamber of Commerce v. Whiting, the Whiting decision that was released by the Supreme Court last year, the court basically ratifies mirror image theory as a form of preemption doctrine. So throughout their decision, they say that Arizona largely parrots, quote unquote, the federal text of the employer sanctions provision of the federal law. The court says that Arizona, quote unquote, went the extra mile in ensuring that its law closely tracks IRCA's provisions in all material respects. Quote unquote, the Supreme Court said that Arizona continues to trace the federal law in defining the state violation. And so throughout the decision, you can see that they're basically nodding approvingly to this Chris Kobach invention, and that is excavated in such wonderful detail by Professors Chin and Miller in this article, that this mirror image theory basically is one method to get around any formal preemption doctrine, or the way that traditionally the court has viewed preemption. So we do know now that, like I said, Chris Kobach played a heavy role in not only authoring the Hazleton Ordinance, but LAWA and SB 1070 and the Farmers Branch. And so this one individual, like you said, to say that academics don't make a difference, absolutely false. Chris Kobach has changed immigration policy, possibly forever. We don't know yet. But given that we've had over 1,500 of these types of laws passed in 1 year alone in all 50 states, shows the power, the tidal wave of this hostile takeover. And so I just wanted to conclude by saying that in Arizona's petition to the Supreme Court, in their petition for SB 1070, they basically asked the Supreme Court, please ratify mirror image theory once again as you review SB 1070. So SB 1070, like LAWA, carefully replicates federal immigration policy and the code, federal immigration code. And so if the Supreme Court decides it will once again ratify mirror image theory, then there's a situation where perhaps the Supremacy Clause evaluation of the Supreme Court will actually match a descriptive mirroring analysis and will ask whether or not SB 1070 closely mirrors the federal law, and if so, perhaps the court will once again find that there's no preemption. So thank you so much.
Margaret, thank you, and in addition for bringing to a head the core issue here and some differences on the panel and more broadly perhaps in terms of whether that ratification of mirror image will deepen a perspective on federalism that, as I understand it, Ernie is articulating, or it's in the realm, or be something of great concern to Lucas and others. Jack, you have, the good part is everyone knows where to find your article now, and I'm going to use that as an excuse to just note the time, that we have the 10 minutes, and we do hope to have some opportunity for Q&A, and ask you to do the best you can within that.
Okay, thanks. Thank you very much, Margaret. One sort of point from 30,000 feet. We really started federal immigration policy in 1882 with the first major immigration regulations. Between 1893 and 1986, there were 6 major amnesties and countless smaller amnesties. And so at least looking at federal immigration policy as a historical matter, we have always had a 2-track system where there are a number of people who are admitted legally and another group of people who come in illegally. And if they behave the way that we want immigrants to behave, if they don't break the law, form families, form connections with lawful permanent residents and U.S. citizens, at least historically, our policy has been to let them stay. So the idea that this is something new, different, it isn't. We've always had a 2-track system. On the legal question, my view, I guess I'm going to have to disagree with Professor Young, fairly substantially here. The case has been framed as a preemption question, but I don't think that it's just a preemption question. I think there's still an aspect of the question as to whether some or all of this is simply beyond state power. Not simply whether it conflicts with federal law in some way, which is the federal question, the preemption question, but whether even if it doesn't conflict with federal law at all, it's beyond state power. Now, Professor Young is absolutely right that not anything a state does that has anything to do with immigration or immigrants is per se invalid. D. Connis versus Bika said, a unanimous decision written by Justice Brennan, said that state actions that have remote and incidental effects on immigration are not, for that reason, always invalid. But that case did say that establishing the core standards for who can come and who has to leave is an exclusive federal responsibility. And the court in that case said that states couldn't do that even if it was authorized by Congress. Even if Congress said, guess what, tomorrow every state gets to have its own immigration policy. At least a unanimous Supreme Court in 1976 said that would be impermissible. My view is that the exclusive federal power over immigration, at least in who can come and who has to leave, includes procedural as well as substantive aspects. And that is to say, even precisely following federal standards, North Dakota couldn't establish a Bureau of Immigration, hire people who just retired from the Federal Immigration Service, and issue visas. Only ones that were in the Immigration and Nationality Act, only to people who qualified, can't issue their own visas. It's also the case, I don't think, that they could set up immigration tribunals and even exactly following federal law, mirror image of federal law. Only people who are actually deportable issue deportation orders and drag people across the border. I think under the decisions as they exist now, that would be impermissible. I also think that the restriction on states controlling immigration applies to direct controls, but also to things that are practically the same. So Farmers Branch, for example, is practically saying you can't be here. And I get this from a case called Henderson versus New York, which was one of the first decisions in 1876. It was not a preemption case because there was no federal law regarding immigration in 1876. So if we're looking for a conflict with federal law, it's not possible in 1876 because there was none. Nevertheless, the US Supreme Court unanimously said that New York could not have its own immigration system. Same with California. And in a case called Chilung versus Freeman decided the same day in 1876. And the critical thing about these cases is that they didn't say you can't immigrate. They didn't regulate immigrants at all. They did it indirectly through the shipping companies. They just said shipping companies have to follow these requirements, transporting people. And they didn't say shipping companies can't bring people in. They just said, bring in all the people you want, as many as you want. We can't control that. That's a federal responsibility, if anybody. You just have to pay a big bond, $500 for each person that you bring in case they cause problems while they're here. And so even that indirect regulation, not a prohibition, just an indirect regulation, no preemption, no conflict with federal law. It was, according to a unanimous Supreme Court, impermissible, and I believe that is still the law today.
Jack, thank you for that directly joins the issues. I'm tempted to call on Ernie, but I'm not going to, because let's take some questions and comments from the floor, and if we get into an interplay, that's fabulous too. Floor is open. And if nothing is forthcoming, I will call on you. Yes?
Problem where people self-reporting aren't going back to the country of origin, but actually shifting to other states.
So, question of, there have been objections from other states?
I think you're going to see exactly that concern has been expressed, and I think you're going to see it expressed more directly and forcefully in some of the amicus briefs that will be filed by next Monday, because it is impossible as a practical matter to isolate what one state does from the impact that it'll have on other states. So I think you'll see that expressed more fully.
Can I just say something about that, which is that it's not at all clear to me that other states would necessarily object. I'm sure some will. But I think we promised we were going to talk about the broader issue of how bad it would be to have multiple policies on this. And I think it's not obvious that this isn't an issue where the states should compete and have different policies and see where the market takes us. Because I think the states that are going to prosper in the 21st century are going to be the ones that are open to all kinds of people and bringing in, renewing themselves demographically, renewing themselves in terms of people with different skills and different backgrounds. I'm from Texas originally, and Texas has a very different theory on immigration. Every time something like this has been proposed in Texas, George W. Bush said this, Governor Perry said this, they've rejected it emphatically because they think that what makes the state vibrant and builds the economy is this constant influx of new blood and new ideas. And so I think if we give states a chance to try their own ways, I think we're going to see what's a more successful set of policies on that.
So can I just respond briefly to that? Because I think it's a really good point, and I think it's true that in the long run, the states that recognize the benefits of immigration will prosper. But I think the question is, what happens in the short run? And what level of discrimination and hostility and suffering occurs, and to what extent is the population, the documented population, the citizen population, those who look or sound like an immigrant to the police that are enforcing it to others, targeted and the subject of discrimination. I think it's very interesting. Texas, to me, is very interesting. And we were having an exchange about this a little bit earlier, because now Texas reflects a more welcoming attitude towards immigration and has for a while. But if you go back to the 1970s, Plyler versus Doe, in which the Supreme Court struck down the Texas statutes that sought to exclude undocumented children from public schools and held that that was a violation of the Constitution. Texas at that point was the Arizona of today, if you will, and the California of the 1990s, where there was enormous hostility towards immigrants. There was law, it was struck down, and I think that in turn contributed to a change in the attitudes, just as when California enacted Proposition 187 in the 1990s, which was also enjoined by the courts, California learned from that. Now Arizona, in my view, needs to learn the lesson as well. But I agree that over the long run, we need to have a society and states that tolerate and recognize the benefits of immigration.
I'd just say one additional thing, and we've left out the medium term, but the medium term, you might think, could be the Romney administration, right? And then you need to ask, do you want uniform federal policy with no deviation at the state level, right? Because federal policy might be better, but it might be worse, right? I want Texas to be able to retain some autonomy, to be open. And it's not clear that if we make this an exclusively federal scheme, then you're putting all your eggs in one basket, and that's what federalism is all about, not doing that, because federal policy might be really nasty in the future.
And Lucas, you go ahead.
No, I have a view on that, but I know we're running out of time, so maybe, because I think there's a difference. Let me just say very briefly. I think there's a difference between state laws that seek to treat people equally, which is what a lot of states are trying to do and provide protection, than state laws that seek to target and discriminate, which is what the laws in Arizona and Hazleton and Alabama and so on seek to do. So I don't think that preemption plays out the same with regard to both of those, for reasons having to do with the norm of equality that's also reflected. But it's an interesting and very, very important point.
I'm passing Margaret the note that says, do we have a hard stop, or can we stop and let those who need to go?
Yeah, make clear, if you need to get to class, get out of here, but we won't have another class coming into here for another thing.
So why don't, if you need to go, this is a good time to go. If you're ready for the sleeves to get rolled up and you want to watch, this is the time to stay. So why don't we take a minute to let folks who need to go, and then we can continue this.
And thank you so much for coming.
So I'm going to turn to the panelists here and vamp at the piano for a moment while we clear the room. But it seems to me that there are at least two issues on the table, maybe more here. One is this, and Lucas, you and Jack have both articulated this, and I think building on each other, that there is a substantive dimension. In other words, as Lucas just put it, there's a way in which states can do something when it's welcoming or treating people equally, and they can't when it's discriminatory or seen as discriminatory. I confess I struggle with that. I mean, I like the notion that particularly in immigration, that there is such an idea of citizenship. We worked a long way and a long, hard time for a degree of uniformity in this. And yet, the notion that it only works one way strikes me, makes me uneasy on several grounds. But rather than plumb the philosophical aspects, let me add the other, which is I think if you look at the tale that you all just told of states, right? That the story of Texas, I see, maybe, so Plyler was 82, okay, and is now a different kind of approach in that way. But it's also a state that essentially says we can have lots of immigrants, legal and illegal, and so long as they're working, that's fine. But don't expect a lot of benefits, don't expect welfare, don't expect an extensive state intervention on their behalf, right? And the point I'm trying to make is that may be the price of that kind of attitude. Whereas in states like California, it is much harder to strike that kind of bargain because the political culture is so different and oriented toward more state provision and intervention. And therefore, Californians, for many reasons, this being one amongst them, are less likely to embrace that kind of deal. And therefore, I'm more expect to see what Ernie suggests, which is variation by state and regional if it's allowed. So I would invite responses to that and for you to have at it with each other.
So I had the last word, so I think it's your turn, and then I'm happy to.
Well, I don't have a whole lot to say about this except to extend the analogy to Europe, right? Europe is another set of countries that have very generous social provision and very, very complicated relationships with their immigrant population, not nearly as open as we are. And it may be that when you spend all this money on each other, you want to make sure that each other is kept in a quite limited circle. And so you stick all the Muslim immigrants in those bad suburbs around Paris and just send in the troops every so often. I mean, that's not the future I want for this country. And I think as long as we don't have a consensus on how we want to deal with this problem, that's what federalism is for. Think about all the basic questions that we're fighting about for other reasons, but the legal part is getting played out in terms of federalism. So that's the debate on health care, right? How much of a welfare state do we want? And that's really a debate about individual autonomy and economic freedom and things like that. But the case is about federalism because it's federalism that allows individual states to make different choices about those underlying policies. And so I don't think there's any one-way ratchet when you talk about the preemption arguments and the federalism arguments. It's not that bad policies will be preempted more often than good policies. In fact, this is the only area I know where preemption tends to favor more politically liberal policy results. Every place else where I study preemption, products liability, for instance, it's the liberals arguing against preemptions and the conservatives arguing in favor. I just like states. The equal protection arguments do go in one direction. And so if you're confident about winning those arguments, then great. I'm not confident that anybody's going to win an equal protection claim here.
Lucas and others, you want to respond?
So yeah, I mean, these are issues that warrant a lot more exploration. Let me say a couple of things. One is with regard to, there's no guarantee that federal law will be better than state law. I agree with that. That absolutely, and our experience has ranged enormously over time. There is something that the courts have recognized that as a general matter, there's a greater danger of parochialism and discrimination in the immigration realm when localities are allowed to regulate in that sphere. And while there's certainly no guarantee that federal policy is certainly going to be better, and we could have this whole separate forum on the problems with federal immigration policy and enforcement, no doubt, but that having a national debate and decision about that will avoid some of the parochialism and discrimination, or at least hopefully. Secondly, the big issue really in many respects is demographics. That's what's happening here, and that's what changed Texas, that's what changed California. That, I think, is at the heart of what has triggered these kinds of laws in Arizona and Alabama and Georgia and South Carolina. And if you look at a map of the places where there's been the fastest growth in immigrant population in the last 20 years, it's in precisely those states, in the places that have enacted the harshest of these laws. And it's because, in my view, a fear of change and a reaction to change, and something that those places have not experienced in a long time. Arizona is kind of in an odd situation because it's both a border state, but it's also experienced the fastest growth of immigrants over the last 20 years. All the other places that have enacted these laws are in the Southeast and Indiana and other places, and there's a nice graphic that I wish I'd brought along. And the third thing I just want to say in terms of state laws, we do have the other kinds of examples. In California, I think, Noah, what you raised is really interesting and important. the so-called state dream acts, where states are providing for equal treatment, not immigration policy, but saying we want to provide equal in-state tuition treatment for all of our high school graduates, regardless of immigration status, implicitly, but what it is it's an equality principle. That doesn't mean the federal government couldn't trump it if it chose to. If the federal government were to enact a state law saying this is prohibited, that would be preempted. But it's a space that the states are allowed to fill in the way of benefits because it's providing for equal treatment of all persons rather than targeting a particular population for less favorable treatment, in my view.
Ernie, I see you ready to do that, but I want to, and I know we're right in the topic, but Jack and Margaret wanted to come in. Let's do that and swing back.
Oh, no, I see the other students trying to storm the room.
Let me do this. Waiting to come into the room.
Yeah, we need to give them 5 minutes.
Okay, so we're pretty much, can we give the last word to Jack? Or?
Sure.
Okay.
I was going to say, I just don't see the argument that perhaps federalism will redound to the benefit of immigrants. It seems to me impossible, the idea that the states will be in a position to say that certain people can stay in the United States or work in the United States if federal law says that they can't be in the United States or it's unlawful for them to work in the United States. I think that regardless of the play in the joints here and the permissible scope of state policy, when it comes to being here and working, we are going to there's at least the federal government is going to have a uniform federal policy, and in a country that doesn't have border inspection stations between states, that seems to me an inevitability. So I don't fully understand the argument that maybe we should have some policy pluralism here, some federalism here, because it will benefit immigrants. I think what we've seen is in this context that it doesn't, and I just don't see how the positives could materialize.
We do have multiple regimes right now.
Well, on the note that we have it already, we're gonna continue this, and
We're going to get a lunch together.
and I invite all of you to do so in your own way as well. Thank you all for this panel. And for coming.
Thank you.
Produced by Duke University. Online at duke.edu.